then if you settle for $15,000, you're going to be settling for 10 cents on the dollar, or put it differently, you're going to be making a gift to the finance company of $135,000. Now, I don't mean to be silly or foolish about it. You're not making a gift. But I believe as your lawyer that your case is worth substantially more than $15,000. Roughly 10 times more than they're offering in settlement. Maybe more than 10 times.
But you can't tell the jury that, and you can't guarantee it. I
can't guarantee it, and I can't tell the jury that there's been any settlement offer, and I can't tell the jury that I think they should award at least $150,000, or that I think they're going to award between $150,000 and $200,000. I can't say any of those things. But what I can do is present the evidence, present the facts, and make the arguments that the law permits me to make. And I'm taking that into consideration when I say to you that I think your case is worth about 10 times more than the settlement offer. And therefore, I don't think you would be fair to yourself or to your children, to your family, even though I know you could use $10,000, particularly at this time with the problems you have. I know how much that money means to you. But I think under our law, you are entitled to substantially more, and I believe firmly the jury will award it to you.
If we settled, I wouldn't have to testify.
That's correct.
I hated the deposition, and I really don't want to go through with the trial.
Mrs. Connors, I know you hated the deposition. It wasn't too much fun for me either. And I know how apprehensive you are, how scared you are about testifying next week. But I'm going to ask you to do this. I was going to say I'm going to insist upon it. Well, let me say it. I'm going to insist upon it. As much as you'd like to settle the case and not have to testify and not have to go through the trial, please don't settle the case for that reason. If after you've considered what my thinking is, and I'm not through with you, I'm going to discuss it some more. If you really disagree with me and you want to settle the case for $15,000, even though your lawyer, the lawyer you picked, your lawyer tells you the case is worth approximately 10 times more, if you want to settle it because you just will not take any risk, you'd rather have $10,000 now after you pay me my fee than $100,000 later. If that's your decision, if I can't talk you out of it, and let me tell you, I'm going to try to talk you out of it. If that's your decision, I'm going to have to do what you say. I won't like it. I'm going to fight with you, and I'll probably fight with you till Monday morning when the trial begins. But if that's your decision, I'm going to have to abide by your wishes in the matter. But if you settle this case because you don't want to testify, then that is wrong. That is not fair to yourself or to your family, and I don't want you to do it. Now, the trial is my responsibility, not yours. Your testimony is my responsibility. I will do what I can to make it easy for you to tell the truth. But please forget about testifying. If the case is tried, I'm going to try it, and you will be ready, and you will tell the truth. And if the truth doesn't help us, that's my problem. All you're going to have to do is tell what you know and answer the questions truthfully. That is your responsibility in the courtroom. So don't make the decision on that basis. Now, do you have any questions about the settlement offer or about why I want you to give me permission to say no? It's not enough money.
If we settled, would I get the money right away?
If you settled the case now, you probably would have the money within a week or two. I would say probably within 2 weeks.
And if we did it the other way?
If we try your case, well, we don't know